This is Real Talk with Leigh Brown, and yes, I'm Leigh Brown. Today's episode has lawyer talk in it, so don't be scared because it's the kind of legal information you need to be checking into if you are still on this side of the dirt. So Lin Wang is here, an expert in wills and trust attorney work, to give you some practical ways to think about how you leave this mortal coil. I hope you're going to enjoy this conversation, and I hope it spurs some action. So I'll see you on the other side. I know that the last thing most people ever want to admit is that they're going to die, which means they don't want to think about the planning for it, which means they don't do anything, which means the world can get really, really messy. And as somebody who is of medium years and looking after my parents who are no longer as young as they used to be, and most of my friends are in that same category. They call us the sandwich generation, where we're taking care of kids and kids that are about to leave the house, and then parents as well. So it's a very timely conversation because we have to talk about what nobody wants to talk about. And so I'm really glad to have you on the show today, Lynn, to give us some good practical conversations to have in and around estates and trust. And so how about you start off by telling my audience who you are, where you're located, and what your professional expertise is, and how long you've been doing it.
Thank you very much, Leigh. Thank you for the platform for me to do the introduction. I am attorney Lin Wang, and I am a lawyer specialized in estate planning, like trust and wills. Basically, people use our legal service to make arrangements about who gets what after they're passing away. And I have been in this area for a little bit more than 7 years. And I work in a law firm specialized in estate planning. Our law firm is licensed in 24 states, including North Carolina. Yeah, so we can serve clients from almost like half of the states in the United States. And just like Leigh, you have mentioned, we don't want to talk about it. But unfortunately, we have to pass our way at some point in the future. So people don't want to go to the probate after the passing away. No. Yeah.
In fact, you know what, Lynn? Let's tell them why they don't want to go through probate, because I find that people have a misconception about it. They think it's no big deal. It doesn't cost any money. And I know that from personal experience in my family, one of the biggest issues with probate is that everything you own is public. And so there is a full display of your personal business for the world to see. And it takes forever, of course, depending on what county you're in and what state how they handle it. So give them a little bit more about why they don't want to go through probate, because we got to start off with the why you need to be thinking about a better pathway.
Right. Leigh definitely knows a lot of things about probate. Yeah.
It's so bad.
It is so bad. Because probate, basically, it is a part of American court system, which is managing the assets if we don't make arrangements in advance. So we know there is the legal hierarchy of inheritance if we don't say anything and we pass our way. So the legal hierarchy will say who gets what. Basically, it will go to the surviving spouse and children first. And if the surviving spouse and children don't survive us, then it will be the surviving parents, siblings, nieces, nephews, cousins, level by level. But how to figure out who are the people closest to us to inherit the assets, or we call it heirs at all by law. And the government, or more specifically the probate court, will disclose our information about our life, about our assets in their media platforms, like their website, their newspaper, magazines, their television shows, and they will disclose our information, like Leigh has mentioned, to the general public, to the uncertain groups and people about our deaths. That is really a very headache thing. And their purpose is for the people to know about the situation so they can claim their rights, if any. However, there are a lot of side effects in the process. First, it will take us 5 to 15% of the probate court fee. Basically, it means if I have $1 million when I pass away, the government will consume 50K to 150K. That is a lot of money.
And that's on top of the estate tax, right? So on top of any other taxes.
Of estate tax, yes. It is for fee, it's not for tax. So it's different things. So if you have more than the estate tax threshold, you need to pay both the estate planning, the estate tax, and the probate court fee. So it is like double hurt. And also, the whole process, like Leigh has mentioned, it takes forever. Like in general, we can expect 1 to 2 years to be spent in the court. And in New York and California, because there is a big population over here, sometimes it can take us even 3 to 5 years to finish the whole process. And because it will be judged by the county probate court. So if you have more people in your county, the more people will die over there, you can expect a longer time to wait for your family to inherit the assets after the passing away. And of course, it discloses your information. So the privacy, the waste of time and money, you should definitely avoid probate by trust. Yeah.
And then because you mentioned the hierarchy that's built into the common law system about where your earthly goods would go, we should probably also take note that in today's society, a lot of people are living in blended families. And so you've got steps and halves and grands and half grands and in-laws and outlaws. And you got this angry ex over here. And maybe they were married 3 times. And so you have really complex family structures,
right,
which means when you go through the probate process, if you did no planning and you wind up in probate, now you've set up for basically a Hatfields and McCoys kind of a war between these different factions of your family, because rest assured, when you're dead, they're going to fight over your assets. I've never seen a family that willingly gave all the assets to the other party because they wanted to. It just, money doesn't make us behave right. Wouldn't you agree that it causes more family disruption than it should?
I totally agree with you. Because like in the probate court, I see a lot of arguments among the family members because everyone wants to get more and they want to get rid of other people. So they fight with each other. They argue with each other about their rights. And when they fight with each other, definitely it will prolong the whole process. So it means it will consume more estates. It will take longer time. It will disclose more privacy and it will cause more stress in the family. So I definitely suggest people to have a trust document because like if we have a trust document, we already see who gets what if we pass away. And the rights will be in the hands of the people we trust, like our families, our friends. So the assets will not go to the court and people will not fight for that. So it will save us the 5 to 15% of the probate court fee. It can save us to 1 to 2 years or even 3 to 5 years waiting time, and it can save our privacy. So definitely a trust is much better than the probate court process.
Now, of course, there's a ton of different types of trusts that are out there, from special needs trust to living trust and life estates and all these other pieces. I'm curious from your perspective, what is the most common kind of trust out there that's easy for people to understand and a good place to get started? Because as I mentioned, for example, a special needs trust, we have a cousin who's got a very high level of autism. So he's nonverbal. He can't really operate on his own. Mm-hmm. We had to work with our attorney on a special needs trust to protect his ability to have government assistance and group home help in the future, because it's a whole thing. But that's a very special scenario. What would you say is a common one that most people could understand and have a conversation about in their own families?
Right. So basically, there are 2 kinds of trusts, revocable trust and irrevocable trusts. And of course, every kind of trust has different sub-kinds under their category. And for the revocable trust, that's the easiest one. And that's the one which most people will choose. Because for the revocable trust, basically, we can do whatever we want to do right now. Nothing will change in our life. And in the revocable trust, we do whatever we want to do right now. And we make arrangements for the time when we cannot manage ourselves our
Okay, so if we can do anything, so if I, Leigh Brown, wanted to set up a revocable trust to give all my earthly goods to you, Lin Wang, I could do that. And then tomorrow I say, you know what? That was a poor decision. I could change my mind.
Right. You can totally change your mind and just undermine everything and do everything all over again. You can be free to do that. So basically, it is saying like, if I am incompetent, like my brain doesn't work, I'm still alive, but my brain doesn't work, who will manage my assets? And also, if I pass away, I don't want to go to the probate. I want my family to take over my assets immediately and automatically according to the trust authorization. So for the revocable trust, basically it is telling me who will get the money after my passing away, so I can have the peace of mind that my assets will not go to the court, will not have a lot of, facts and arguments after my passing away.
Okay, so sorry to interrupt. So I want to ask about that time frame piece.
Right.
So with probate, it takes an uncertain long amount of time to touch your assets. Meanwhile, there's cost associated with a passing that people may not be prepared for, like the cost of a funeral, the cost of a coffin or cremation or whatever they want to do. So if I'm in a revocable trust, and we'll just say I did a more normal thing and put my assets to my kids, they get access right away. So there's no delay there because it's already in writing and notarized and recorded and all that.
Correct. Because once we have the revocable trust, we record our assets in the name of the trust. For example, if you check your deed of the house, and if you don't have a trust, probably the deed is under your name or the name of you and your husband or your wife, right, jointly. So if we have a trust document, we need to change the deed from our name to the trust name. So the government knows about our arrangements. And once we pass away, we don't have to go to the probate court, forget it, please. We can just designate people we trust, for example, our adult children. And they can take the trust document, their own ID, and our death certificate to prove our death. And they just go to the government deed recording office so they can claim the house immediately back.
Okay, so since you're a lawyer and I'm not, I'm a real estate agent, I'm not trying to play lawyer, but one of the questions I've gotten is, if Bob and Jane have a house and they're listening to this episode and they think, well, we are not getting any younger, let's put our house in trust so that, like you said, it's documented, the government knows. However, they still have a mortgage outstanding on the house. Can you put the deed in the trust while you have a mortgage with a bank, or how does it work if somebody hasn't paid off their property?
They can put the house with mortgage in the revocable trust. Because for revocable trust, they still need to pay tax, the mortgage, when they are still alive. Nothing will change when they are still alive. So they don't have to worry about the mortgage. Because what the bank cares about is whether you will continue paying for your mortgage and the interest. That's the most thing I care about.
Yeah, they want their money.
Right. Because that's their money, whether you will pay me money. So they don't care about when you have a revocable trust, but because you still need to pay the money. But if you choose the other kind of trust, irrevocable trust, you cannot have any mortgage. Because for the irrevocable trust, it is not only about the arrangements after I am incompetent or if I pass away. It is the arrangement right now. Basically, I give up the rights, give up the assets to my families, my friends, my family, my children right now at this current moment, in exchange for some benefits. On one hand, I want to avoid my own creditors.
Okay.
I'm facing high risks tasks every day. I don't want to, take risk of all of my assets. I don't want to be broke if I do something wrong. So I put it in the irrevocable trust. And I say, okay, I give up the rights. I keep my hands off the assets. So that's not my assets anymore. And if I do something wrong, you cannot take your hands in my irrevocable trust property because I gave up it already. And
okay, so if Bob and Jane own their house outright, but Bob went wild and took out a bunch of loans that he's defaulting on, he can put the house in an irrevocable trust, and that protects the house from the creditors for the other debt that he took on?
Not.
Oh, okay.
He has to put the irrevocable trust property when there is no any mortgage or burden. If you still have mortgage or burden on that, you cannot put it in the irrevocable trust.
Well, no, I thought you were saying if they own it outright, so they have no mortgage on the house.
Okay.
But then they go get other debt. So he gets consumer debt, car debt. They take out a loan for a line of credit to buy a business, and he defaults on all of those debts. If the house is in an irrevocable trust, is it protected, or can those creditors still come after it?
It is protected. However, the house cannot have any mortgage on that.
Okay, so as long as the debt's not collateralized by the house.
Right.
That's how somebody could take out a bunch of debt and not lose their house if they put it in an irrevocable trust.
Right, but they have to put the house in the irrevocable trust before they take that.
Okay, gotcha.
Right. Yes, like for example, if you already have debts and you put your house in the irrevocable trust, it doesn't work in that way.
Okay, because I've been in real estate a long time, Lynn, and during the Great Recession, there were a lot of people who were losing their houses for lots of reasons, not paying taxes, not paying the HOA. It was more than just mortgages. And they would find every which way they could to walk away from debt obligations. So, okay, that helps me clarify that it's not really a get out of jail free card to use an irrevocable trust.
No, yeah. You
have
to have the trust property in the irrevocable trust first. So give up first. And then you avoid the subsequent debts. If you already have the debts, you cannot do that. And also, once you put the assets in the irrevocable trust, it cannot be a collateral anymore.
So why would you use an irrevocable trust versus revocable? What's the primary reason for going that route? Doesn't it seem better to have the flexibility of revocable?
Yeah, I mean, some people even when they get older, especially when they get older. So sometimes they think, okay, I have had enough money. I don't have to keep all of the money in my hands. But I am worried that in the future, I will have debts. For example, perhaps I want to be in a business which can give me a lot of fortune, but perhaps it will cost me debts in the future as well. So before I have any debts, I can put part of the assets which I don't want to use anymore in the irrevocable trust.
Okay.
If I am a failure, it will not be gone. It will not be everything will be gone. And
so basically, this is the reason that before anybody even thinks about any of this, they want to sit down with a trust and estate lawyer like yourself to work through, here's the pros and cons of the different ways to structure this.
Right.
Basically, don't set this up using ChatGPT.
Yeah, right. Yeah, no. I don't think ChatGPT will be very helpful because I have tried it before, but I find it out it doesn't know a lot of things. Right. So I have to give them the idea, I want to have a revocable or irrevocable and what kind of protection I want to have. And then it can give me the documents. But if we are an outlier, we are just we are not a person related to law. I don't think we have enough knowledge to tell GPT, ChatGPT to help us.
Yeah. Call a lawyer, everybody. I'm not a lawyer. She is a lawyer. This is not legal advice, by the way.
This is not
a lawyer. We're just talking.
Right. We're just to give the general idea. Yeah.
So when you're thinking about putting stuff in the trust to protect it with privacy and for speed and for making sure that your assets go where you want them to go, what would you say in your 7 years of experience in this space, what is the one thing people overlook that they should be asking about when they do go see that attorney? What questions should they be asking?
I think a lot of people, because they don't know the general idea, sometimes people only care about I want to make sure if I pass away, I can avoid probate, but they forget the trust can give them more protection than that. Actually, everyone will die sooner or later, right?
We're guaranteed.
Yeah, we guarantee that. But the trust can survive us. So we can make sure even if I pass away, the trust will still stay over there. And in this way, we can set up some rules in the trust to make us protected even when we pass away. So on one hand, we call it protection clauses. Like we can say, I only give the assets to my children. And if my children have creditors, like if they owe money to others after my passing away, or if they get divorced, the creditors and divorce cannot take the money away from my children.
Oh, so you can protect them from gold diggers by using the trust?
Right. So like even if I pass away, I can give them more protection. And on the other hand, we call it restriction clauses. Oh, like, sometimes our children, they are not mature enough. Like they want to use up everything in one sitting. So we can give them restrictions in the trust. We can say, okay, you cannot use up everything after my passing away immediately. Instead, like I will give you like salary. Like every month, you can take $3,000 from my trust property.
Okay.
Or before you are 30 years old, you can only use 30% of my trust property. So in this way, it's not only about avoiding probate, but the children will get extra protection and restrictions from the trust rules. In this way, even if we pass away, the children will get good protection. So that's something I want more people to understand. Yeah.
So when you talk about them the children being able to take a distribution from their trust, one thing that I've been finding out in North Carolina with our state law here, when my children have an investment account, which is an UTMA, the Universal Trust for Minors account, that account, maximum age I can set on that is 21 years old. North Carolina says at 21 they get that account. That's in an investment account. In a trust account, am I also restricted to a maximum age? Or because at 21, I think we can agree most young people aren't quite ready yet for inheriting things. Could I make it 35 or 40 if that's my choice using something like a revocable trust?
You can make it at whatever age you want. So that's the freedom the trust can give you. It is like a platform which gives you the total freedom to do basically whatever you want to do within the category of law. So so if you have a trust, you can definitely make the age older than 21 years old. Like some of my clients, like I am like Asian. So like Asian parents, they are more, like conscious when it comes to money and their children.
Sure.
They will set the time at, 25 years old, 30 years old, or even older, because they want their children to be more mature when they have access to their trust property. Yeah.
Or give them a chance to do a little bit of work before they get the boost that the parents have saved up for them, because work is not a bad thing, y'all, and your kids should learn how to work even if you save for them. Okay, so when I'm thinking about children, I'm past the age now where I have to worry about guardianship. When you're putting together the trust, is that where let's just say you have minor children, do you set up the same kind of revocable trust for minor children? And what tips do you have on thinking about I think for most parents is a worst case scenario where both parents perish at the same time and now you got kids?
Right. So like when we talk about minor children, we mean the children under 18 years old. Because when they are beyond 18 years old, they can manage themselves.
In theory.
I mean, in theory, yes. I mean, perhaps they're not mature, but they can do that legally.
According to the government. So.
According to the government, yeah, but perhaps not according to your family rules. I mean, it really depends on you. But if we have children under 18 years old, we have to set a guardian for them. That is mandatory by law. No matter whether you think, okay, my child is a genius, but he or she cannot manage anything before the child reaches the age of 18 years old. So in the trust, like if the children are beyond 18 years old, I will ask the family, the parents, whether you want your children to be the people who will manage the assets directly or not. You can say both. You can say, okay, I want the children to manage the assets themselves, so they can do that. Or they can say, okay, I don't think they are mature enough. I want other people to do that. Okay, you have the choice. But if you have children under 18 years old, you have to find out who will be the guardian or the trustee who will manage the assets if both parents pass away before the children reach at least the age of 18 years old. So that's something I want the young parents with minor children, they have it in mind, because a lot of clients come to me. but they feel lost when it comes to who will take care of their children, like minor children, if you pass away before they are 18 years old. Because, like, especially when you are not very close to your family, like when you perhaps you live in the US, when your family are in other countries, like Switzerland, China, because we are immigrant countries. So a lot of people, they have the families all over the world instead of just nearby them. So sometimes they have to think about, if something bad happens to me, what kind of life I want my children to continue. So whether I should find my family back in my home country to take care of the children, or whether I have the trusted friends who can take care of my children in the United States, whether I want the children to change a lot, like if I pass away, they have to go back to somewhere else to continue their life. So that's something I really want the young parents, always young children, to think about it. Yeah.
I had not considered that international challenge that people could encounter. So if the parents are naturalized U.S. citizens,
Right.
kids, so the kids are born here, they're American, parents are naturalized.
Yeah.
And the parents are from, let's just say, Argentina. They're from another country altogether. And then the parents are killed in a fiery car accident, and the grandparents are in Argentina.
Mm-hmm.
Can, under U.S. law, I guess it depends on the state, your revocable trust could set the guardian trustee to be an international person to manage that?
Yes, you can. And for the guardianship, there is guardianship of property and guardianship of person.
Okay, so it's two different things then, the finances versus who's taking the kids.
Right. So for the guardianship of property, the country is more generous. Basically, you can say whoever will take over your assets if something bad happens.
Okay.
And they will not see anything. But for the guardianship of person, it is more strict because you will take care of the children. So no matter whether you will appoint people outside or within the United States to be the guardian of the people of your minor children, they need to go to the court for the verification. The court needs to control that to make sure that people will not hurt the children. So I will say for the guardianship of property, perhaps you can find the people outside the United States, you can totally do that. But for the guardianship of person, it will be easier if you can find people within the United States. Because you have to remember the government needs to approve that. And if the people are outside the United States, there is a higher chance that the government will reject it. Because they will feel it's hard to, supervise the guardianship. So,
and then you think about, that's difficult if you have your revocable trust. Holy smokes, if you have probate, it's never going to work out the way you wanted it to work out. And your kids will definitely pay the price if you have minor kids, because doesn't the probate court decide who gets the kids if you don't have some kind of document set up?
Actually, the probate court will basically decide who gets the money. And the surrogate court will decide who gets the case. So it's two different systems. Yeah.
Come on, y'all. I know you don't want to do it, but you're going to have to. You're going to have to reach out to a specialist in trust and estate law, and then sit down as a family and have these conversations. And I can understand why you work in so many states, Lynn, because as a country, we've gotten so mobile and people's families are scattered all over the place. I know that when I'm handling an estate property here in North Carolina, quite often the people handling the estate, the kids, the grandkids, the heirs, they are in other states and they're trying to grapple with this, with their state laws versus our state laws. And then you have the logistics and take all of that and double in with the emotion that goes with losing a loved one while you're trying to manage the estate. So it's important, y'all, to spend the time getting it correct right now so that you can avoid all of the headaches later. So, Lynn, before I let you go, I'm curious as to the worst case scenario you've seen. What was the one crazy scenario that you said it didn't have to be this way? Give us a worst case.
Yeah, I'll give you a worst case. Like, one day, a lady, called me. A lady, I think in her late 50s. And the lady told me her boyfriend, not husband, but her boyfriend, has a trust for her. She is the beneficiary and the boyfriend is the grantor of the trust. And her boyfriend passed away. And in the trust, the boyfriend said, okay, if I pass away, I will give a particular house with the address, specific address, very specific, to my girlfriend, so to this lady. And then we find out the deed. But the deed is not recorded in the name of this trust. Only it's of another trust. And the other trust says, if I pass away, I give the same house to my daughter from a previous relationship. That is a very juicy family drama. I know.
That wasn't here in North Carolina, was it? Because I met with some people that had a very interesting scenario similar to that. It kept them from selling the house because they were having to fight over who actually inherited it.
It's in Massachusetts. So, it happens everywhere. It happens everywhere. And then the lady is very furious. I can understand her, because she
thought she inherited it.
She's expecting the house to belong to her after he's passing away. But right now, all of a sudden, everything changes. So she fights with the daughter from the previous relationship. And they argue a lot. They say a lot of, bad mouths to each other. And as a lawyer, I feel, very tortured, So, yeah. So, when you have a trust document, please record your assets in the trust which you want the person to inherit the assets. And if you want to change the beneficiary, please change the deed recording as well. Otherwise, they will argue with each other. And both of them have some standing because the girl will say, okay, if you have a trust document and if you want to be protected by the trust, you have to change the deed. So why didn't my late father feel to change the deed? Because he didn't want the house to go to you. He wants the house to stay with me. But the lady said, the girlfriend said, no, he just forgot to do that. He had the true intention to leave everything to me. So they argued with each other. They wanted to go to the court, but I don't handle litigation in general. I handle the, drafting. Yeah, because, I don't want to waste my time and waste my emotions, especially because people...
Exactly. You can't help but take a side. It's human.
Yeah, and people really feel very... I guarantee you that is not the best time to negotiate with them because they are in the worst mood in the situation. So they argue with each other. I say, okay, perhaps I think you should, mediate with each other. Perhaps you should talk with each other instead of going to the court because the court will eat up a lot of money. Or if you really want to go to the court, perhaps I can refer you to the litigation lawyers because I really cannot handle this thing. It's a lot of things for me. So yeah, so that is the worst scenario I have ever seen. So please.
And he was dead. He didn't have to deal with any of it. So the other bright side, y'all, is if you set everything up, even if you screw it up, you're dead and your heirs can sort it out. But we don't really wish for people to fight over the dead guy's house. That's not a good way to remember anybody.
I know. So it's not a trouble for the deceased people, but it's the trouble for the people who survived him. Yeah. Mm-hmm.
And I'm guessing they probably sold the house and split the money. Is that what wound up happening? Do you know? Did you go look it up?
I don't follow up because the lady is very insistent. She says, I have to get everything. I say, okay, I will give you a litigation lawyer, but she doesn't want to use the litigation lawyer. So I don't know what happened later on, but I guess it is not a happy ending anyway. So yeah.
No, you just wash your hands and say you did what you could do with the paperwork.
Yeah. So I just explained to her, okay, I'm sorry, I cannot help you anymore. So yeah, so you can argue if you want to argue to get everything. Because if you want to get something, you have to sacrifice something. You have to give up something.
Right.
It just doesn't want to give up anything. So, okay, I see. No, sorry, I cannot. Yeah.
So let's see. The two things we learned from that story. Well, first of all, if you're dead, you don't have to worry about it, but your people might fight. Second of all, you probably do want to trust because at least they could get resolution from the attorney. But third of all, you might even want to ask if somebody makes you the beneficiary. I guess you better ask them if they ever did a different trust to somebody else in the family, because obviously in the heat of the moment, he forgot about his daughter, which is a whole different sad scenario right there. But go see a lawyer, y'all. This is timely. We're approaching the end of 2025. Check it off your list. Make your appointment to go see an attorney. Lynn, if somebody wants to reach out to you and find out about what you offer and how you can help provide counsel and guidance, what is the best way for them to find you and your law team?
Yeah, so my number is 612-231-2060, 612-231-2060. Thank you.
And of course, all of Lynn's contact information will be in the show notes for this episode, so you can reach out to her. And y'all, seriously, get this done on behalf of my entire family that's been dealing with some issues with trust and estates. It keeps things clean, and that keeps your family together. Lynn, thank you so much for coming on the show and giving us some really good practical ways to think about things and some information. I really appreciate it.
Thank you, Leigh, and thank you, everyone. I appreciate this opportunity to talk about trust in the wills as well. Thank you.
All right, guys, hit the bell to subscribe. Say something nice about Lynn in the comments or something you learned. And most importantly, come and see us next time on Real Talk with Leigh Brown. Now, if this episode brought you value, made you laugh, cry, or in between, then don't forget to subscribe, leave a 5-star review, and share this with somebody else in the real estate trenches. You'll find a Real Talk with Leigh Brown on every major podcast app, so hit follow, and I'll see you in the next conversation. Don't forget to DM me if you've got a story. I might just want to feature you next.